94.7 Asempa FM so ne Ekosiisen dwumedie na wasogu so a otie no medin your sable so 30 minutes after 5 make us a lawyer Andrew Ejapa Mesa atnase oye MP secondary constituency and nano me di tuja ema mo say enche of course into the announcement no will be done. I've already put it out on air. More mokoswa etie you know enti enche I mean announcement ne ba ya de betridwa ede amamo. We'll come back in studio before see ebekona yedi nkomo efa the fresh applications are NDC have filed already. Now yenim se party no petitioners no file applications me no back was for if there's a request for some document from the Electoral Commission. The first respondent. The Etosu Mienu was an application for review of Supreme Court decision disallowing or more interrogatories no into your files are review. The Supreme Court sat and mode of trial ni bibia true in data trial proper start which is Ochana 26th January. And the petitioners not sign up file another application for stay of proceedings. Say Ochana trial na ye pese start no ye nhome so kakra na Supreme Court no nhwenka omunsem ni nyina enwie on their review and a request for document no. And the yatesa petitioners say file another application. Say the grounds are they call for review from the Supreme Court no. Or more even more information on person almost sign at the account into your file a fresh application no. Say they want to change some paragraphs in their original statement of case into announce no omode echo. Yebenya one spokespersons need for us to understand what really any in somewhere omopese omode echo Supreme Court CC aba lawyer mesa ewa lawyer ye kona o kasa efa fresh applications you think say it still leads to one thing the petitioners in any case ab initio.
Absolutely, without a doubt.
Ekosiisen on Asempa FM.
And something no. In all honesty, Mugiram Zazi.
Oh, the man.
Obi. Application of filing now. Ordinarily. Kebia new assembiaka. Was under ultimately justice na yahwe na se ehwe petition nankasa yenuanom NDC for well Mr. Mahama former president wa file na relating to all the applications that were filed. Initially, or file for leave to correct mistakes. For petition, or file application to
request for documents, no
interrogatories.
Interrogatories. No.
Now, or file application to admit facts. Now, or file
Ekosiisen on Asempa FM
application
for review.
Necessary also or file
in the application of review came and a stay of proceedings.
Now I file application to amend portions of one statement of case in the review. Now or correct some paragraph on was replace a certain paragraph 28 also. And again, what's it? Or additional grounds our file to assist the Supreme Court with additional authorities to determine
the review application.
Now, the law is in the bosom of the judges. Yes, I agree. file a petition who legal authorities rely on. You are enjoined to provide them in your statement of case. But ultimately, the law is in the bosom of the judges. Ochede per one rules already in every decision we will be
Ekosiisen on Asempa FM.
Wafa and brand all the authorities into consideration and some we will deliver judgment. Now, amendment to the Supreme Court rules was for a purpose. To the extent that even under the new rules, joinder of parties, 2013, His Excellency Nana Dankwa Akufo-Addo, then candidate, post the election, na Vice President Bawumia, na Chairman of the party, Jacob Ichebilamte, or file a petition. It was against the President-elect, President John Mahama. NDC for file the M1 na was sponsor
President Mahama,
the candidature of President Mahama, and so they needed to necessarily be made a party. Of course, that in itself took some time to determine. Rules of Court Committee Attorney General Okahu in 2016, just before another election after 2012, with the Chief Justice and everybody that is a member of the committee met. And now we'll take a decision there. Look, 2013 experience was not the best. In Saba Kon Yaba for that, Yaba Chief Justice, but at the same time, make sure the case be Ababiano with an elections petition should be disposed of within a certain time frame. And see, the processes that led to cutting down or not capping the time for the petition was well thought through. Now, what the rules bear there, even amendments will not be tolerated. Indeed, say file one application now because of the 21-day period now one. Make sure that you put in everything that you want to be determined in the application before the court, so that say respondents who will responder immediately thereafter no yaba case management ma you determine memorandum of issues na no can we na sana you proceed. So one wonders why that all of a sudden and the interrogatories request to admit facts
on Asempa FM.
Now, admission of facts
as part of the discovery process.
Petition, as part of which discovery process. Look, those are discretionary,
yes.
Applications that when you bring the court have regard to the circumstances of the case.
Or grant
each case, case by case, would either grant or refuse. Afal interrogatories, court to know in its wisdom, or say, having regard to the circumstances of the case before us.
The questions were not relevant.
It's critical in arriving at any conclusion to grant your application or not. In any event, such the nature of the CI 99 now. These interlocutory applications are not intended to be entertained.
The spirit of CI 99.
Absolutely. Unless, of course, NDC4, well, the petitioner is saying there, the absence of the interrogatories will not enable him to prove his case.
The arguments are that the interrogatories will help them.
Now,
I'll help
court.
No, I want the petitioners in setting down their issues and also inform the witness statements they will present before the court.
Witness statement on your body.
My witness a friend Obeka, which you should have an idea of.
No. Although
yes,
he has to know.
Yes.
Have you read the petition?
Okay, no, 5 witnesses.
Many problem of number, they can even call 1 or 2, whichever. Indeed, Mekede Mr. Chikata Nankasa in court. Okay,
Asempa FM.
They have said that they will call as much as 5, but they can even call 1 or 2.
Yes.
What is going to be contained in the witness statement? Or the facts in support of your petition, the grounds of your petition. In the witness statement, Biano ought necessarily to follow what is contained in your petition.
Absolutely.
Now, so the question is, what is contained in the petition that they don't have answers to or are unable to prove, that will require them to, by all means, have the interrogatories responded to? In any event, I can easily one response.
Which of them? The response to the petition?
Oh, it's an amended petition that we are dealing with, because the original petition has been, by leave of court, riddled with mistakes. When I was for amendment, so it's been amended. So it's the amended petition and the amended response of the first respondent and the second respondent. On the DK, what is the crux of the petition?
An error in the declaration of results.
And they don't have the basis for that assertion that the declaration and the error can be determined with the witness statement that is going to make. Witness statement, nani de nkanu dewa, ana say eda some kokota. Unhia witness statement biya, eba frawe witness na weke na box ni mu. Now I can ask some oral evidence.
On the evidence in chief.
Evidence in chief. Yeah, we are. And the opposing side, neither the defendant or the plaintiff, whichever way, the other side, will cross-examine. Now we are. Our re-examination be to clarify some issues in that. That process, no, over time, court realize it.
Waste time.
Waste time. In Sasambia, witness no pedal can be in support of your own case. True. Netro and depose affidavit that you verify the facts as contained in there. And so no, when you know witness box number, none there only do me tender witness statement.
Yeah.
And not there where we want some can. Then the opposite party can then cross-examine
based on my okay.
And then this was when you must more.
What's the
because that's exactly what they say. So let them write it.
No, but they say
some
of the issues will have to be responded to
by
the
who? But that's why there's a response. Now, actual petition is a respond. They provided an answer to your petition. Who complained actual in your petition? The EC has provided an answer in which they have even made admissions that yes, we made an error. Big deal. Who doesn't make an error? But the error that we made relates to
Ekosiisen on Asempa FM.
EC chairperson now announcement of the total votes cast. Or the replace total valid votes cast. However, in the declaration, in the computation of the figures, I did determine whether somebody had 50% or not. We use the total valid vote cast as is required of us by law. They cannot deal with this matter in a normal course of the trial. They cannot. That's what is feeding into the suggestion that they are not ready. Osende Obi, yeah. Is assembly awa Kembiano. Madame Jean Mensah will write a witness statement.
Which she has done.
Which she has done and filed.
Yeah.
In accordance with the orders of the court. Nana Akufo-Addo, through ne power of attorney, Mr. Mark Menu, will file witness statement in accordance with the orders of the court. Pursuant to their answer to the petition. Now, where does some court do? I wasn't no. Say EC one more Supreme Court are more bisa questions. The questions then to be bisa on the cross examination. Because say read one application for interrogatories now. What's in there? They want those responses, request to admit facts. They want those responses to the interrogatories and the admission of facts to assist the court in expeditiously determining the matter.
Yes.
So according to them, the applications now what happening now is to inure to the benefit of the court. Court is that we are okay.
On your relevant.
We don't need your assistance because it's not relevant. On the one day proceedings. Now one call for a review of the decision by the court would deny one application for interrogatories now. Now Obi, Mribo, share. Yes, I agree. There.
Now, Mr. Inman, no me pede yet to be no meba just some 2 minutes. Just some 2 minutes. Me pede yet to be say why this new application. One of the spokespersons for the petitioner, lawyer Sami Jemfi. Sami, akwa ba saying.
Obi, onyame adom me ho ye na so.
Nyame adom me ho ye papa. Nyame adom me ho ye papa. Na yeah, me te unka chepa. Me no me te unka che.
Nyame boa bia o china ye behia.
Fantastic. Nti we dey Ginas not lawyer messa say or ka bibi de na no asi na afi wabam. Lawyer, nti aba na pedeka.
I agree. The court or the Supreme Court wa pass decision wa ko review wa one position. Yes, I agree. It happened in the past. But Obi, bear in mind that the court so make a determination be yes, it's guided by precedent. But the precedent no is related to the specific facts of each case. And so it is, and of course, the Supreme Court has also on several occasions refused an application for review. And says the trend of cases
Ekosiisen on
are
Asempa FM
on a reviewer. To look at matters like this.
Yeah, always
not
successful.
Suffice. Because we can't order natural facts that were not available. And then substantial miscarriage of justice.
Yeah.
Which one does the denial of the interrogatories satisfy?
Okay.
So it's really an exercise in delaying the matter. Ordinarily, coming on from because I have an issue with the Supreme Court decision even to include the determination of the preliminary matter, legal objection they raised in the judgment.
In their final judgment.
Absolutely. Because the issue that the MPP is raising is that look, this petition Nankasano does not meet the test
of 64-1.
That's right. That enables them to invoke the jurisdiction of this court in the first place. So throw it out. So that we don't waste time into going into the matter. But it is also not unusual for the Supreme Court because of the intent that look in constitutional matters. It is always good to hear the full story before we make a determination, and in the final determination, include our ruling on the preliminary objection. The talk that the court is rushing them. By the time that we were doing the rules, we didn't know. The court is sacrificing justice with expectation. Oh, really? How? That interrogatories automatically fall be our grant. Is that it? And so if it's denied that, then the court has erred. I cannot understand.
Okay. Lawyer, in the Maminte Namen Membra, lawyer Sami Jemfi, and about an hour ago when I ensaka fresh application be a mode accord motion on notice for leave to file an additional ground of review replace paragraph 28 of the original statement of case, and file a supplement to the statement of case. When so for him, lawyer?
Me never that say. They kind mamenchia wa poundful. Wa helpful ni wetie
Ekosiisen on Asempa FM.
Lawyer Japan Mesa or studios. Na yeni anamsini bia o studio hunti na lawyer Mesa can send be bring no. Me pese min crew bono Mesa tie feedback bi na aboama wono a wotie yen no etumi ate NDC ya semwa ya dia kwa to Supreme Court anim no asiye. Because even before I explain to you process ya filing and no I was say nipa etie yen no ete the antipotia John Dramani Mahama or they assembly akwa down Supreme Court. I was say Boama Ghana Fudina Tiasie. Why is John Dramani Mahama, by extension the NDC, in court over the 2020 presidential elections? Na obi nzankomo we yedida ne tofa bomu nyina ne se Ghana abatwo ene abatwo no nsunsu anso a e wo se ye bobo ne yedi tudwa no ya mamra eno ye mra kunyina ye de chichiro men e the 1992 constitution no ene ye mra bebre
Ekosiisen on Asempa FM.
E wo se ye faso ye no Inti Article 63, Clause 3 of the 1992 Constitution, you know, akase. The Ghana yakoto abasi ye mampenya. Die obedim kunim no. Ajese emma papa ya betu ni nyina no. The friend of valid votes no. Wenyamu ohamu chichimu edunum eni echiri. More than 50% of the total valid vote cast. And sana yakase wedim kunim. Na Article 63 no chirim say ya tu abano na ya di abato no sunsu anso betudwa na wono a wosi akan no omumu bia enya more than 50% of the total valid vote cast. I was say abano ya kwato no foforo between the wedi first and the wedi second and only a kind of run off no because there has not been any clear winner. 2020 ya kwato aba. The returning officer for the presidential election was Mrs. Jean Adukwe-Mensah, the EC chairperson. On the 9th of December, or the Abatuano Nsunsu Betuga. So what your figures are?
Ekosiisen on Asempa FM.
Declaration ni mua. Eye clear say, that declaration eye Abatuano Nsunsu Betuga no. Yen to me, yin to mu wombremu mani ye because I papa. Clearly, the figures no the buyer no. Number one, are they up? Number two, the trend say, Omampenya kufuado one way ne abano because per mamena kasa figures, easy for kasa figures no. Omampenya kufuado enya more than 50% of the total valid vote cast, and therefore there should have been a runoff on the basis of their own declaration. And ya treating how okay percentages are ya all the 12 candidates ni bomua per that declaration unya more than 100%. Mathematically you need say any possible.
Okay, for clarity, Sammy, on the basis of EC now declaration, not on collated figures by the NDC.
No, on the basis of the EC's own declaration. That is what we are challenging. The air can say, Yaba Miji Mensa, or no yet returning officer. I was that's why I saw a presidential election for 2020. Bobo. Nebubono.
Ekosiisen on Asempa FM.
She must do it with honesty, integrity, and transparency. And unti say Okobobo Abano. Now I was a 1+1 you 2. But no, when you 1+1 is equal to 3. Obi any wo be dia tu amana ye. I was here the Nuko Jinam no be chiri. So Okobobo Abano. Now your mother said you obedi kunimino. I was when you have more than 50% of the valid votes. But Wakobobo Abano, they also wedding kunimino when you more than 50% per her own declaration. Emremuno enimu yentimi yintu. And it yes Mami Mensa. my total valid votes do we say yes a percentage of them on Pinyo Kufuado and yes I know yeah percentages of 12 candidates in Abomua ebro 100%. And on 9 channel okay says yeah the Techiman South and many now from John Mahama or Pinyo Kufuado still obeying Kunim by getting more than 50%. And also yeah no Obwa and yes I understand. The do could not run what Babi Chili.
Asempa FM.
Any easy for nam say, oh, and this is for Nyasembia. Nay, ye mamma on a phone keke. Nana no phone, you know. Wababa be correcting the mistakes. Yes, correct.
Ekosiisen on Asempa FM.
There is only one declaration of the 2020 presidential election results. And the correction, I will say, why you know, declare it. Correction, I will say, why you know. You are talking about an unsigned press release that you publish on your website. Mistakes, and also change first one. No. And someone will catch you and say, oh, yeah, press release. Now, what the about the corrected total valid votes now? One paya, uti, you know. Now, that correction, you know, it doesn't affect a ma candidates in the NIA.
Asempa FM.
That press release ni more. Ni ya say, uboa. John Mahama what the so 1,707 votes. O Mampenye Kufuado what the 174 account. So it was not only the total valid votes you sought to correct or adjust, but you have actually adjusted the votes of the candidates without the knowledge or involvement of the candidates of the agents. Abrahuddin and Marley Man who trying to do that. Article 23 and Article 296 of the 1992 Constitution and CI 127 so the toast Habawi. And no so-called correction
Ekosiisen on Asempa FM.
Master, we are still have fast. And I have to a baby. Now you have about one so. Now results will be seen there we don't know. This year will be without say. What was the total valid votes for the 2020 presidential election? Can you tell me? You can't.
Isn't it on the EC's website?
It is not there because on 9th they declared one figure. On the 10th they published another figure. Now in their answer to their petition, they have introduced another figure. So they have
Asempa FM.
How am I introduce you? Then apart from that, if you take the summary result sheets, 275 constituency summary result sheets are, or one catastrophe no mujina so they declare results, which they have published on their website. And I am challenging Dominic Isiyaboa and the Asempa FM production to say, this is a public interest matter. Mom create this spreadsheet. That's the mobile thing. Now 275 summary result sheets of the 275 constituencies in Ghana. If you are publishing on my website, it is there.
Ekosiisen on Asempa FM.
Na mo hwe. Se mo total valid votes na mo benyano. Ebeye anything close to the 3 different total valid vote figures is via banana. You will get another different one. So on the 9th, one figure. On the 10th, through an unsigned press release, not signed by the returning officer or anybody from the EC, another figure. Then they go to court to introduce another figure again. Then when you take the summary sheet from the 275 constituencies, and also you get another result. Is Ghana a banana republic? And so we are saying, sir, it is in the interest of our democracy.
Asempa FM.
In defense of the 1992 Constitution, specifically Article 63, Clause 3, I say your very presidential election here, and also we have more than 50% of total valid votes. And was saying this, yeah, they are saying we court. And yes, I was you know, you say a bad precedent. The implication would be, say, Ghana for Yana Yamama, you two, you say, you to obey penny for no. They say, dear, you pack a credit, but dear free and some. You're to a bar. So be a rainy, so be rainy. So be more than 50% of value on Asempa FM. Will be declare. Will declare we non compare results on them. Not failure and then what the Bakwaba, or China what the Bakwaba, at the same of the Bakwaba. This cannot happen. and should not be allowed to happen
Asempa
in
FM.
any democracy. And into petition now, court, it is on behalf of all Ghanaians who deserve to know the truth and the true facts pertaining to the 2020 presidential election result. And that is why so now we MPP nimpa and was saying yeah what guess we are court. Even Jim Benson should be happy to say that court because it gives her and the EC the opportunity once and for all to demonstrate to the court, the nation, and the world what the true results are. So when we are then this should not be any difficulty. Now let me come to the processes we have found today. Obi.
But I mean, before some about processes, my other question, if you have the figures, so different figures now, do you have them in front of you? I'll be to my Boba.
Yeah, in front of me.
Okay, Boba here.
Good. Good. So, good.
Ekosiisen
on the
Asempa FM.
9th of December declaration.
Yes.
And at the way the whole person who look na what the papa and the paper naturally. Jimensa can say the total valid goods. I say a mother do a Ghana for 4 years need dimu wamrem. Na ye ma papa no. Na ye 13,434,574. 134,34574. Now, on the 10th, at the exchange, and bear in mind that this 9th declaration is the only declaration. The unsigned press release, no, whatever on the website, is not a declaration. Per CI 127. Now, and no more so the car say, oh, manu from keke. The na make no meet here. So, now figure na make can. 13,119,460. That is 13119,460. It is in that unsigned press release. Also, when I make one kasa with the pen actually you didn't present that declaration as simple. One can do team and what paper too. What say man from here? Now the name person
Asempa
13,180,460. Obi so what another one to it down.
Yes.
Then NDC do for court. John Ahmad do for court. Betray the real figures are. Mama no the so-called correction now on the 10th now and on what that and some trouble for Ghana. I will be adding them and I say man no any mistake or no correction no or the figure ne papa na bano. They say almost the south figure not to change and the another figure back. And I refer you to paragraph 24 of the answer of the first respondent, the Electoral Commission, to the petition before the Supreme Court. At paragraph 24, this is the new figure. 13,121,111. 1312111. So, Obi, which correction is the correction these guys are talking about? The 10th, you gave us one figure. I mean, on the 9th, you declared one figure.
Ekosiisen on Asempa
why a
FM.
press release? What does in where we are a press release? And the another figure back. I say, Assembly Court, hoping that you will even come and stand by the second figure. I will call that day when they buy now. What do you want to change the another figure? Hadn't done for your real gospel. The reason why they keep on changing figures is because of where we have been. And Obi, let me tell you something. Even this new figure, none of these figures were generated or published by John Mahama or the NDC. None. Even this new figure, 30,121,111. Obi, 275 constituency summary sheets now. I want my website. Would there a spreadsheet? Obi, I can share it with you. You will get now. Would you get a valid vote in a boom? You will get a figure which is different from this third figure too. Now, about what you have to Ghana have from 92
they see now. Yenya results on quite different by 4 or 5. You know understand I mean?
But Sammy, me pacho say so share figures now with the two, the corrected one on the 10th. Now share what is contained in their petition, paragraph 24. Said you can difference near 1,650. That's between the two figures. Are you saying say and no new year muno and I say then 1,650?
Let me tell you what I'm saying. What I'm saying is that if the MPP for Detroit now, because you cannot, even if the difference is 1, it means that somebody is forging figures. Because you have a collation constituency, raising, national, about when your results. Why must you keep changing the results like a mother would change the sanitary pass of a 3-month-old baby? There be a result necessary. Even if the difference is 1 vote, it means that somebody is desperately trying to adjust figures to achieve a certain end. As an accountant, but so me, what's all your balance sheet? Not balance sheet, of income and expenditure, a balance sheet. Now, and I'm saying, now what you be or 30 boats, we are humanity can, but some years on the balance sheet in balance.
Ekosiisen on
another figure and balance it. No one's not another one and balance it. No one's not another one and balance it. What's also difference between me and a calculated me bokrono cram bokrono calculated. I think what did that? Ubokrono crowd bokrono calculated. Is that what they are saying?
It will bring me to my next question, Sammy. It will bring me to my next question. Sammy, my name family my next question. So
just leave it a credit.
Okay.
You see the reason why every election you have to Ghana, you have to really the result enacting into law. Election we know in specific terms the total valid votes. It is only the 2020 presidential elections and at the same net we don't know the real total valid votes. And then here very important to say constitution the denominator for determining who the winner of the election is, which is the total valid votes. So if you are having total valid votes changing every day, clearly it calls into question the credibility and the integrity of that result. And we are telling you, sir, even beyond these figures which keep on
Ekosiisen on Asempa
FM. Declaration now, which is the declaration of the 9th. And some more time in Womuno. Tell me, the year Juma, the Senate of Antonio Kufuadu, more than 50%. Now somebody says, in spite of all these issues that our black and white, we don't have a course of action, we can't go to court.
Or more, Kasano.
You see, that decision by the Supreme Court to defer their determination of the preliminary objection raised by the respondents to the time of the deliver judgment is the first defeat the MPP and the EC have suffered in court. Because you see, the essence of the preliminary objection was to avoid a trial. No one person has time to cry. Near 50, near total demands and no. And you know, you can't raise your objection. I said, no, I am Momu, and in Nasubia. Supreme Court, any Momu, you have 50. You had the attempt or objection.
Well, Omayana as part of the issues, and only the first issue, actually.
Then that being said, they're not
Ekosiisen on Asempa FM.
Supreme Court meeting, that is what it means. Now, Obi, interrogate with us, and you may kakakra. Interrogate with the
Sammy, now me question Bibu Sawo, and Mami Musanyi. The question was, sir, based on figures, ni bibi audi amaya the belief, the confidence you have in your petition, why should you rather be the people who seem to be putting spokes in the wheels of the Supreme Court relative to the hearing proper? And yanka yanyan in starting here case, strip the Electoral Commission bare, let them know so they did a shoddy job. But it seems that Mumono and I say mu put spokes in the wheels and now application way or channel application way. Is it a lack of confidence in your case?
Obi, evidence will be some way. Is it those who argue like that? Omo maka say DC. Yeah, application to ye delay case. I mean, omo lawyers need the better omo. You see, but omo lawyers omo kasa sama. It is either say omo your man so we be
Asempa FM.
Ghana for any. And I say law na ye chiro mu school.
Ekosiisen on Asempa FM.
Either they have forgotten the law their teachers taught them at the Ghana School of Law about procedure, or they have deliberately decided to be mischievous. Every student of law knows that there is no law without procedure. Constitution is my opinion. Say, oh, problem, about to transfer, we need to court to an election petition. And my court, put me on my court, I embra, you did this answer, and then you find the rules of court. And here, the Supreme Court rules, CI 16. Okay, rules anymore. Excel say, who the petition no bar, and just you fit, you saw the idea of what did. You be find the case management. And you see a pentence, you say, oh, what the case about in young threat. You see, no make not back of young chimans.
Asempa FM.
If you have a court, but not big Mukrano, you case management to agree on issues and the mode of the trial and how the whole trial will be conducted in consultation with the parties and their lawyers. The court comes to a certain determination. And now the yeah. It is in the High Court rule,
on Asempa FM.
It is in the Supreme Court rule, CI 16. Every lawyer worth his or her salt should know this. In 2012, election petition. Or didn't ask them come out court and you do. Or didn't ask them come out court, or your amendment. And then you baby as you know your amendment in one you. Your court case management or file application to serve interrogatories. There's a question in Sembisa on the issue. And my court to need you to. If I thought I'm the lawyers, yes, in 2012 petition, were they seeking to delay the case? When the Supreme Court granted those applications, was the Supreme Court seeking to delay the case?
The Supreme Court found the questions relevant to the case before it. The court today says the interrogatories are not relevant.
Your question was not about relevance here. Your question is say you free say you okay to there. I don't know file application, you file up young content. Let me read to you the dicta of Justice Che. In the case of the Chief Justice of the Republic of Ghana and the Attorney General ex-party Justice
Ekosiisen on Asempa FM.
Justice Dochan Samokayeni. It is often said that justice delayed is justice denied. The reverse of this is also another common saying. It states as follows: justice hurried is justice varied. There must therefore always be a delicate balance in the expeditious adjudication of cases to ensure that either way, no one is unduly disadvantaged by the vigilance or indolence of the judicial system. It is all a pentem. It has no basis in law. You know, you pentem. But then I have pentem. You the mrano and the pentem. In any case, Obi, I just will be our own law. Yen the law that ocean civil procedure that. And a very argument to say the local court with an application to serve interrogatories on a party, questions on a party. Let's say open would delay case. Because the purpose, the purpose of interrogatories is to narrow the issues in contention between the parties and fast track the trial. And the
Ekosiisen on Asempa FM.
The person we are no. The person we are no said about yes, at a man's phone now. You what dear to Budadano? Me, have me home and sound so no a kill manso. What is got here?
Yeah, to fast track the trial, the Supreme Court says no thank you. The trial can proceed. You are setting down issues. Let's go ahead. Why the fixation on the interrogatories, even after issues not have been decided on?
Why the fixation on the interrogatories? They say the 1992 Constitution. Actually, Supreme Court for media same will be back, but no my young people. And it's almost if I say more never. Now we're born so put me apply for review. Our 1992 Constitution. Unless NPP4 and never back there which provisions or rights in the Constitution we should resort to and which ones we should not resort to. The Constitution is supreme. Every party before the Supreme Court or yet dissatisfied with the decision of the Supreme Court, they can apply for review. And there were precedents for Ghana. Obi, Supreme Court judges in Now, when you say your decision, unanimous decision. Never review no over the sound.
Ekosiisen on
unanimous decisions have been overturned upon review before. Yako review in line with the provisions of the 1992 Constitution and the rules of the Supreme Court. Because the man might hold twice. Now, can say, court no decision or the two that, and I will take here on the application for interrogatories. And I'm not telling you, no court no yen fonso. Now, I also say the court no yen fonso womrem and the kind fundamental errors of law and the exceptional circumstances are court no and stand there. And to hear your application for review now, you can't yama me answer in the womb. Yes, the Supreme Court must say the entire moment you walk in Emma Dimensa and answer 12 simple questions. Now, Obi, before I go there.
Asempa FM.
Kano Crew. Dimensa nye on dia. Why you do clean? We declare results here, Papa. Now, and this the start the questions, sir. 12 simple yes or no questions, sir. Why must they have a difficulty answering simple yes or no questions? If they are indeed interested in fast-tracking the trial like they claim, yes or no questions where this woman...
Why must who have a difficulty?
Even in an interview, because with or without this court matter, you can walk into the office of Jimensa with an appointment and go and ask her those 12 basic yes or no questions. Basic. If you have nothing to hide, only a Bolivia, why are people desperately protecting you from answering simple questions?
Jane Mensah has not said anywhere, say, answer question. It is the Supreme Court that thinks. No, but the point is, their response, their response plus Momu issue, second respond and respond. The Supreme Court will have to compare and look at the two, and they've decided, say.
We are opposed.
Yes, they are opposed.
Because your questions and your answer that.
But the opposition did not compel the Supreme Court to rule the way they ruled.
The question is that they were opposed. Almost your answer. Omanpenye Kufuado lawyers so omo na SCS omo pese Ghana for ogu dokura no. Omo so yeah ma answer. We are also opposed. And the Supreme Court also say yeah man answer. And you say the Supreme Court nyaj e was answer. The issue also answer and saying but
I mean, unim because of education. I remember
the three grounds of the review application.
The point that I'm presenting, Busan said, even in more application for amendment of more original petition, no, they opposed. But still, Supreme Court nema mo kwan say mo nkonko amende. No. Inti omo opposition no enye and tie the hands of the Supreme Court. The Supreme Court in this case said the interrogatory is not relevant to the case, and that's the reason why they rejected it.
Nobody has said if you for opposition to questions now you have to answer tie the hands of the Supreme Court. They said they opposed it. So let's put that on public record. The Mensa, who is the chairperson, public officer. Per Article 23, you are supposed to discharge your duties with transparency, fairness, and all that. With or without any petition, questions we are what I will answer. You are running away from simple yes or no questions because you know you have something to hide. That is my conclusion.
But these are questions you can put to her during cross-examination. Questions you can put to her during cross-examination.
That is the most
Ekosiisen
ridiculous
on
argument
Asempa
I've heard.
FM.
This is lawyer Mesamo. They should not think that the audience of Ekosiisen are all novice or if you like ignorant people. Even they are non-lawyers who understand these processes. It's more kasa. Show Ghanaians some respect. Say, why are you filing interrogatory? Because you can even get the answers from the Mensa during court examination. Really, then interrogatory it should not even be a rule. In 2012, Omampenya Kufuado filed application to serve interrogatories on Afarijan. Couldn't they have gotten those answers from Afarijan in the witness box during court examination? Why did they so fast?
Okay. Sammy fast tracking. The grounds for review. Lawyer Mesamre me pacho.
Good. Inti ya consistent kakra ni nya chomono ne when it suits me Omampenya Kufuado ye Ghana ni change o Mahama ntino ono de to file interrogatories. But John Mahama dia
to the grounds for the review, please.
Good. The three things ni aka. So the first thing they say Obi.
Hello?
Ekosiisen on Asempa.
Hello, Sammy? Hello?
Yes, Obi, what you
Quickly, grounds for the review.
2012 election petition, no?
Asempa FM.
Omampenya Kufuado Kwai and filing interrogatories on the basis of the High Court rules CI 47, specifically Order 22. Now, the entire to be Major Mahama Kwai manning the same thing, they say. Emrana Sisa. They say, Yanyam Rebia, your friend CI 99. And some Rana say election petition, I say, ye need within 42 days. In the Nam Sembreni Swanintino. To me apply the same precedent they set in the Kufuado case in 2012 in this particular case because of the time constraints CI 99 at Yaba. Now, simple CI 99 in Poa. And Mahokwain say parties in Poba Court in an election petition case, that is, it doesn't even allow for amendments. Into just a new rules about and into to me applies that precedent. The air can say the kind new rules now banner
Ekosiisen on Asempa FM.
Nimua a case to me and this a party be your man who quine a man apply for interrogatories or apply to serve interrogatories on another party. CI 99 does not exclude
Asempa FM.
Pre-trial processes like interrogatories. And in fact, CI 99 provides for pre-trial of 5 days. And untino, contention, a lead counsel lawyer, Chachuchi Kata, what put on across in his statement of case. Ne say, Samrana, CI 99 na, court to dina so the boo, it take his decision now. Omo ame supply Mrano because Mrano respectfully, Emma parties who quite fail to go through pre-trial processes like interrogatories. Now, indeed, interrogatories, say, Mame Hokwai, na mi misa Electoral Commission in Simfua Kakra, non fa no ye Mrano. And no pon a boama manson no election petition a content. So
which interrogatories are granted at the discretion of the court? You know that.
On Asempa FM.
Interrogatories. The court granting you leave to file interrogatories, no? At the court's own discretion.
Is that yes, but they're part of the rules. And so say if there are two binding Supreme Court decisions, now the court is going to depart from that. They must clearly explain that. We are saying, by relying on CI 99 to say, oh, Manama only 42 days, and until to me allow for interrogatories, you made an error of law because there is no provision in that law you relied on which says that.
But did you say there are rulings here binding on the court? Sammy, said there are rulings here binding on the court.
Of course.
The Supreme Court?
The Supreme Court, yes, can depart from its own decision. especially when the decisions have been given per incurium. That is without recourse to law. And when they are departing from their decisions, they give reasons for doing so. So the fact that they are clothed with the power to depart from their own decisions doesn't mean that they do that capriciously. Anyone who is a lawyer knows that. And special circumstances.
But they don't do that always when the earlier decision was per incurium. I don't think that's what the
that's
process
not what we are
takes.
saying. What we are saying is the grounds for departing from that precedent, a error in law, because a manner wagina swaka say enuti and I may apply the same decision I took in 2012 involving Akufo-Addo, when I allowed President Akufo-Addo, candidate Akufo-Addo at the time to file interrogatories, or reasons in TIA, you cannot apply that. A error, fundamental error of law, because what's a CI 99 China winning yes, sir. Meanwhile, CI 99, the BNU are say disallow interrogatories because you have to determine an election petition in 42 days. And our contention is that interrogatories even before the 42 days, because they're not a content. It doesn't contradict the spirit of CI 99 to allow for interrogatories. It is in line with the spirit of CI 99
to
allow it, because
grounds number two. Grounds number two.
Number two, because I said, my explanation is the Supreme Court, when they make a fundamental errors of law, and where there are exceptional circumstances, other exceptional circumstances that we cannot go into because of time. The law says they should review, and in time pass, in arriving at the decision, say, John Mahama and the lawyers are crying, easy, simple questions, we know. Emrakra omujina so ko tu ye no. Emra omu ko tu jina so de take his decision no. Omu ko tu tin ye.
Omu ko tu tin.
The law wrongly. Respectfully, and I'm making this point, I mean, with utmost respect to the Supreme Court. Because where the arguments are, lead counsel, what should I say? Supreme Court has said, per Rule 69. Let me get you the specific rule. Okay, per Rule 69, C4, that's sub Rule C4 of CI 99. Parties in an election petition case now cannot even apply for amendment. And I'm going to say, Daddy, I'm running out of 2 years. Rule 69, sub Rule C4. It doesn't even talk about amendment.
On Asempa FM.
The right rule you should have quoted. Rule 69, sub Rule A6, which is what talks about amendment. And even that rule, it doesn't apply to the petitioner. It applies to the respondent. What it says is that the respondent, in this case,
Asempa FM,
and your Mampenia Akufo-Addo, they cannot amend their answer to the petition. What is what I'm saying? So, almost answer, almost file it to the petition. Rule 69, sub Rule A6 says they cannot amend it. Then there is another rule which says that the petitioner can't also amend his petition to introduce new grounds of the petition. So if you make clerical errors and you're not allowed, you can amend. But you cannot amend to add another ground.
Yes.
So lawyer Tatutukata argues in his statement of case, the law Uko 2 says CI 99 and allow for even amendments
Ekosiisen
in the hearing of election
FM.
petitions now. Rule 69, sub Rule C4, no, it doesn't even talk about amendments. You got it wrong. And therefore misapplied it.
Okay, Sammy Emreninti, touch on the final ground no, in 1 minute. Now, member lawyer Mesa so
the final ground, no, you now have to do with the exercise of discretionary power. which is governed by Article 296 of the 1996 Constitution.
Asempa FM.
The case I am making, respectfully to the justices of the Supreme Court, and say, yes, like Obi Buchanan, whether or not to grant applications for interrogatories, they are the discretion of the courts. But in exercising that discretion, respectfully, their lordships are supposed to do that with fairness. And when it is a miracle, we didn't do the me as watching respectfully. Now, a miracle, we didn't so. I can't say one my time. I am easy for simple questions. We know. A miracle and can be answered. Now, in 2012, my petition na no kwai mane ye sadia na nie e kwakwa kwese selectivity
Ekosiisen on Asempa FM.
fairness be enye adwuma in the way you are exercising that discretionary power and until medium ye be frem say
okay,
this is no rebellion. This is our constitutional right.
fair deal.
No lawyer worth his or her salt should or can say and the Supreme Court has decided I'm on press what your penitent don't apply for review. In what law?
Sammy, my nasi, Jinazo mintie lawyer mesa. No, my mintie lawyer mesa me pacho me ba. I'll come back to you. Yenimre wakasache.
No, in 1 minute.
Sammy, hold on. I give you. Sammy, just hold on. I gave you enough time. Jinazo me pacho. Lawyer mesa, pocho 18.
Patapay na onkesi bibia. Se Sami Jemfi opede oba kana sama koba studio ha. Ne na yebebe issues na no na yaka. Obi, it is not my role or duty to litigate them case our Supreme Court in Asempa FM Ekosiisen program you do. Ochina
Ekosiisen on
Motsi
Asempa
bia
FM.
court no obeden obasit na we interrogate
Asempa
applications wa file before the court. Hwe America ma sam no ono ntina make chere momfama no nsi at a certain point.
Yeah.
Anya dama waji ma no ekesi ban because I know them. The point is this, look, ibia anyone any issue with how many applications that they want to file. What do I file 1,000? As far as I'm concerned, because His Excellency the President is doing his job. Bear in mind, however, the CI 99 amendment was done when they were in power. And it was for good reason. In see, na rules of court committee, what's na ya, what set them time no? Interrogatories. Or your discretionary
court committee, what has that got to do with that?
order,
This was a judiciary.
Supreme Court, and our court biano, or you're vested with that say litigant or any case, not the application be done by court no or share case no particular circumstances, particular facts of each case. Now we make a determination whether about grant and I don't get grant. It is purely discretionary. It's the fact that in the past elections petition, Excellency Nana Dankwa Akufo-Addo file be based on the circumstances of that case, Supreme Court or granting that relief. Does not mean that necessarily, as of right, every time we are interrogatories be the court has to grant it. And read the order of the court now. It's clear.
Now he makes the point there. Discretionary powers are not absolute powers. They should be utilized according to law. And he cites Article 296, one of the grounds for the review.
Where is the capriciousness and arbitrariness of the application of that rule or the ruling of the Supreme Court? Ruling no only Ose man can initial paragraph.
Okay.
Also, interrogatories under common law is discretionary. It should be granted or refused when all the circumstances are taken into consideration. It should be noted that the questions seeking The questions seek to elicit answers to the issues raised by and the relief sought in the petition. Interrogatories must be relevant to the issues and relate to the matters in controversy between the parties. In this case, the petitioner and the first respondent. The court is of the opinion that the crucial issue of relevancy has not been established in this application. Relevancy. That was the crux of the decision of the Supreme Court.
No.
No, further to address. No, go further to make reference to the Akufo-Addo case of 2012. And said that yes, post that, because of the matter and how it traveled in the court system, no, news here in Ukraine or prohibit the amendment of applications before the court, all with a view to achieving expediency in the determination of the matter. It wasn't as a result of the expediency necessarily.
Expedition.
On and one application was refused. It was relevancy, as is clearly stated in the ruling of the court. But I don't have a problem. Of course, the Supreme Court would make a determination of the application tomorrow. And if it makes sense, if there's some value, if they convince the court, they won't grant one application, one file additional grounds, now one opportunity to go on a review and all those kinds of things. The court would make a determination tomorrow. But you see, one. Obi. Samidi Mfinde Osi 1,651. Which is the difference between the so-called 12 December corrected figures.
Yeah.
And on court action.
What is in the petition?
In the paragraph 24 is immaterial, and that say error no cry one. It goes to show there will be pay.
Yes.
This is a petitioner whose petition himself has corrected. In fact, application they filed in they are seeking to make further corrections in their own statement of case that they filed just last Friday. That cannot be spoken to. In any event, Obi, Yensi Kroma in the Supreme Court, whatever complaints of overvoting, voting without biometric verification, and all those kinds of things that the petitioners complained about in 2012 should be material to affect the outcome of the election. We're not in this now. In any event, interesting. They can only confuse NDC. They can only confuse themselves. Electoral Commission don't provide the figures too. On the 9th, timer, Mrs. Jean Mensah all declare results. No. She said that total votes cast, not my certain figure, 30,434,574. However, total valid votes that were cast were two different figures. She changed the reporting.
Ekosiisen on Asempa FM.
And the next day, we issue statement. They look, and then they made an announcement. Instead of the total valid vote figure, I use the total vote cast figure. But in the computation, Obi, the total valid vote figure of 13,119,460 was what I used. That's it. NDC for say Supreme Court for Mama Madam Jean Mensah kon mo nya dam correction no. No ordinary no can there 13,434,574. Until they should hold there to that. and make a declaration there based on this error. My men will admit there. Look, my announcement no, maka 13. You see total valid vote figure rather than the total valid vote figure. Until they should hold her to that and proceed to make an order there based on this erroneous figure. No, Obia in 50% into one order rerun. Obi at be that.
Ekosiisen on Asempa FM.
At be that.
Obi.
So me
this
or then I know
petition, and I'm not the Supreme Court, but Mass Law School Moko Kakra. And I cannot believe for the life of me how anybody would think that this petition will succeed.
Asempa FM.
You think so?
Ah.
All the grounds are warm now.
Oh, Obi have a grounds on Hama.
Ah, na mo kicking answer.
And now, oh, he's talking relative to one application for review. No grounds on me main now.
No, before that, different figures.
Different figure. What was it? Also, I calculate the figures are electoral commissioner or the men over 100%. No, the contrary is this: 11 people know apart from Nana Akufo-Addo and 1% anybody more. Now, 1% out of 100 or back at him. It's a question that the NDC should be prepared to answer. Because say it deduct all the percentages of the 11. Obaka 51.295
on Asempa FM.
Which is what the EC gave now.
Thank you. Easy mistake. Obi. The mark 1 + 1 ain't any 2 the mark 1 + 1 or 3 not or chinama badam so no. And then the mark 1 + 1 equals 2 the mark 1 + 1 equals 3 minimum. Or you 2 no ye. I say no. I can 3 na de 3 and ye hold. Not me that. Obi Mr. Damasemi at be that. I cannot understand. Osende. Hey, Mr. Muhammad need the film. No percentage is what publishing. Hey, you behind the film no age and another Akufo-Addo na continue that. Okay, 51.295. So this is no. My minro no okay 51.595. In say no fair no. No boy your can 51.595. Ye the ni na boma oh yeah 100.3. Oh, it's our your friend there yatsi. Ne ye Mr. Muhammad mu na de nya won ni fi obaka hin. This is what they want the Supreme Court to endorse. Now oh yeah one pink sheet ibia obi o.
Ekosiisen on Asempa FM.
Summary sheets, no collation sheets, right from the police stations, through the constituencies, through the region, to national. Every political party will be. Now you want that so far. Month the NDC for what's it? Oh, Madam G Mesa on the 9th, about 13,434,574. On the 10th, so about 13,119,460. No court to so about 13,121,111. Our difference now 1,651. Nana do that Akufo-Addo win election by more than 500,000 votes. In fact, I want to one petition. All the figures that they complain about pardoning now 5,620. So far, one can share Ghana for that. And here now, so you can figures boom no. Yenya X. They haven't said so anywhere.
Yeah, so also that is not the cracks of the petition.
So what is the cracks? So what
the
is the
petition is the error in the declaration.
Oh, and that man, no mistake. Or you see,
absolutely
13. Obi. Minyotai. The fact of the matter is that second vote now across Ghana. Valid vote cast ni nano. Oh yeah, 13,121,101. That's the fact. The mistake that the woman, the electoral commissioner made, you know about 13,434,574. You say we should ignore the fact. We should ignore it. The fact does not matter. What the will of the people of Ghana was is irrelevant. And that, as far as you are concerned, the error that the electoral commissioner made, the returning officer, is what the Supreme Court should use as a basis for declaring the result to the effect that nobody won. Are we serious? No, are we serious? Obi, Missy, Abaya to Waganani Nakanina Boma.
Yeah, you've made that point.
No, let me make it further. Oh, yeah, what's your computation, EB? And then the agents were across Ghana.
Yeah.
Wonder why you're not. Is it different from what the electoral commission put out?
Around the same.
In fact, yeah, we haven't had a much more transparent election in this country ever. Osande Ekosiisen one website CCM in UK say Obi. Every single regional collation sheet is there. Handwritten, pen. Every single constituency pink sheet is there. On your type though. Pen, handwritten. Now, what you do, Supreme Court want to calculate you now who they owe. Yes, figures are what are being now. Oh yeah, 16 million, 30 million, 440. Out of the total votes that were cast, no, it be invalid. The Supreme Court cannot make that determination because it's all there on the face of the document. No, you want there. And one of why your mistakes were one petition that were correct back and forth, man. And that day one file what's why your mistake was paragraph 20.
No, also will replace.
The replacement is not to correct an error. They've made an error. They state it in the affidavit. And it's in the affidavit.
Sorry.
That the court should give them an opportunity to replace even today. So right from 31st December till in there. Why your corrections are everyone wondering is okay. See material. The court should allow them to continue making corrections. But the will of the people of Ghana should not be respected by the Supreme Court because the electoral commissioner's error in announcing, not in computational, announcing now no fume no can 13,434 111
okay,
as opposed to 13,11 in Toronto. Nobody had to be there.
That
would amount to what is the greatest fraud cry in this world ever.
Welcome. 3 minutes.
It's unbelievable.
Sammy, 3 minutes. Wrap up, Naminko.
Obi, I am the lawyer Japamesa. Waje the 7 justices of the Supreme Court or more presiding over the election petition. Waje Omeduma. Aye. No,
Asempa FM.
Ekosiisen
on Asempa FM.
The Omoyentia. Omonya justices of the Supreme Court presiding over this matter. And yes, they can confidently pronounce judgment. But is it Ghana for any 1+1? Ghana for in Japan. And regardless of what happens, Ghanaians will know the truth, saying 2020 about to he didn't win the election. And someone I
said I issued a clear caveat before I spoke.
Okay.
That it is not my duty. No, it's important. I made it categorical that it is not my duty to rule on this matter. The Supreme Court to do his job.
Sammy, meet you. Sammy,
Obi, there are like a for your declaration. Jim Benson or your returning officer. Yet, what baby, all declare results. What's an offer? The total valid votes for your seat. And I was at the chair,
Ekosiisen on Asempa FM.
About all court or the correction and the coin. Okokoti, and or did the so-called correction of Rakoya.
Asempa FM.
Mammy, you're okay, no quibby bit no. My assembly could do court, no. What is that? No, what is that? The correction, not answer the figure for Fraba. What say, already an important, you know, my young Casa. Yenya no no to figures nisa. Na 2012 ya tuaba. And after we can declare valid votes back home. And at the say or the for buy. And an election petition by or cancel the for buy. And the pink chief uki kabo mu winya for fra. And kamesa ni MP before ko beti ase. Sa astre semu. O ka kire akwa ketekete kwa obeti serious. Ya tuaba. Why can't we have one definite result? Obi, we are one of the most reputable journalists in this country. Tell me, what is the total valid vote for the 2020 presidential election? You tell me. That would be unfair.
13,119,480.
480 source.
Electoral Commission statement on the 10th of December.
In fact, that statement says 460. Check paragraph 24 of the EC's answer to the election petition of John Mahama. Almost say the figure is 13,121,111. So which is which? Which one should we believe? Where in the world
Asempa FM.
where between different results? And you are saying that we should not probe. The EC should not be given an opportunity to court to come and substantiate the alleged mistake or so, and justify the corrections. Corrections, they are repeatedly corrected. Every day they correct their corrections. Do we even know the results now? I declare as president, does he even know the results? Grandpa, results are winning. What was the total value vote? What figure would you tell them? Is it the figure of the 9th, the 10th, or what the EC has disclosed in their petition on the 24th?
The gazetted.
You see, lawyer Mesa, on kind of petition now, on kind, on the NDP lawyers.
Ekosiisen on Asempa FM.
We are challenging the constitutionality of G. Mensah's declaration. These mistakes and contradictions, and it only goes to show the lack of credibility of the results declared. Is
that not what they used?
But the crux of our case, they say, yes, what do you
is it not the figure?
No,
the figure that they are using in their computation.
Oh, Mami Kamasem. In the declaration, the law defines how the declaration should be done. Who should be invited to the declaration? There has only been one declaration. And until someone say that declaration was wrong. The so-called correction has it been declared? So what declaration?
So are you saying, sir, on the 10th, Anka, on sign fresh uncle for Nebio, and sign a fresh declaration?
If you do a declaration, which is a requirement of law, defined by law, and you say you have gotten it wrong, you think without the law, without recourse to law, you can correct it.
Ekosiisen on Asempa FM. Asempa FM.
But in correcting our mistakes, we have corrected those mistakes in accordance with law. You can say that I am a public officer. I have a constitutional duty to perform. In performing that duty, I have a mistake. I won't follow the law. What correction are they even talking about? Is it that of the 10th? Or that which is captured at paragraph 24 of the EC's answer? Or that which you get when you do your own aggregation of total valid votes as captured on the faces of 275 summary result sheets of the 275 constituencies in Ghana? Which of the figures do they want us to believe?
Sammy, I will see you in studio tomorrow.
This is shame and an embarrassment. And nobody with a conscience, nobody who believes in democracy, nobody who believes in this constitution that we are working with will defend this mess.
Okay. Sammy, I would expect you in the studio tomorrow. May in all
of this, Portugal send this for the Excellence and Abdul Kwakufu donate 6,730,587 was Has it changed?
No.
Mr. Dramani Mahama net 6,213,182 was
No.
Christian Kwabena Andrews net 105,548 was
No. Oye,
Ivor Greece net 12,200 was
my endase.
Obiani vote onyeno on sesen.
Yate.
Ekani na boma, it will give you the total votes that actually cast or participated in the election.
Yeah.
Say, hey, all the votes that EC issued, you know the figure. In say, you valid voter, individual be on your boom. That's only 130,119,460 on corresponder. Then you can make a case.
Lawyer Andre Japamesa, any attending. Can you me much now? So it's been